Hello everyone, this is Vandita. I am studying in Sri Venkateswara College of Engineering, Bangalore. Today I am going to discuss about research methodology. Today's topic will be patent and the process of patenting. First, let's see what is patent. A patent is an exclusive rights granted for an innovation that generally provides a new way of doing something or offers new technique solution to a problem. So this is the main definition of a patent. It is an actually a patent is an exclusive right for the innovation. So when a person does some innovation, he has rights over that innovation, saying that it is his own innovation so that no one else copies it. This is called as a patenting. The exclusive rights legally protects the invention from being copied or reproduced. As I have said, patent is an rights that is given to an inventor. These rights are legally produced because some other person does not copy his patenting. In return, the invention must be dissolved in an application in a manner sufficiently clear and complete to enable its replication by a person with an ordinary level of skill in the relative field. So this is patent. Next, let's see the conditions for obtaining a patent protection. There are set of criteria as provided in section 2 I, J of Patent Act. The Patent Act was published in the year 1970, which must be fulfilled for a product or a process to qualify the grant of a patent. The criteria encompasses novelty. First, novelty. Let's see what is novelty. Not part of state of art. Novelty means it is not a part of state of the art. The innovation claimed in the patent application is new and not known to anybody in the world. In other words, the innovation is not in the knowledge of public, not published anywhere through any means of publication, and not to be claimed in any other specifications of any other applicant. So this is novelty. These those 3 points which have said earlier, like not in the knowledge of publication, and these 3 points are under novelty, in which the innovation is defined. The next criteria is invention step. It's not obvious to a person skilled in the art. The innovation is a technical advancement over the existing knowledge. So, inventive step is something which you do inventionally or innovative, like no one has already done this and you have done it in a new way. So, it is a technical advancement over the existing knowledge. Where the existing knowledge is there, inventive is like you bring some changes to the existing thing which is new and no one has developed yet and possesses economic significance. So when you do something new which is not existing yet, it possesses a economic significance in the market, not obvious to a person skilled in the concerned subject. Next is capable of industrial application. So what invention you do, it must be capable of industrial application. It must be used frequently in the industry. When you design such a product, then it will be very soon famous. Not for the benefit of society, the invention is capable of being made or usually in any industry. Next, let's see the process of patenting. In India, the process grant of a patent is a lengthy procedure that may take anywhere 3 to 4 years or more. So in India, when you want to do a patent, it will take around 3 to 4 years of your time. The major steps involved in the process of patenting is given below. First is filing of application. Filing of application is when you want a patent for your invention, you need to file an application to the higher officers, saying that you want a patent for your invention. Next, after the filing of application, we will be publication of the application. Next stage of after the filing application is publication of the application. Next, after publication, we need to request for examination. After you publish, the examination involves the higher officers checking your innovation, whether it is legally procedure for a patent to give. Next is examination issue. Like in the examination stage, they just see if there is any issues or any complexities or complexibilities coming ahead. Next, after everything is done, you need to grant of patent. So when the higher officers check every step is correct, the last step is the grant of patent. Next, the first is filing of application. In India, patent applications are filed with the Indian Patent Office under the Patents Act 1970. So the Patent Act is in year 1970. The publication can be filed by the inventor or agreeing or the legal representative. So in India, the filing of application is done by a legal representative who is going to see if your patent is correct or wrong. The process starts by submitting the request form, including Form 1 and Form 2. Form 1 actually states the application and Form 2 states the specification. Specification involves specifying what you need for your patent and what are the needs you will be giving in your invention and the other relevant documents. A provisional specification can be filed initially to secure an early priority date, followed by a complete specification within 12 months. So only the application to complete its specification, it requires 12 months. That is one complete here. Next, publication of the application. After you have finished filing of application, the next stage is publication of the application. Publication of a patent application is a crucial step in the patenting process. It involves making the details of a filed patent application publicly available through the Patents Office or database. This step is governed by patent laws and ensure transparency while protecting the application rights. Next stage is request for examination. A request for examination is a formal step in the patent application process where the applicant requests the patent office to examine their application. So in the request of application, the patent is examined. This step is crucial as it initiates the subjective examination of the patent application to assess whether the invention meets the patentable criteria. Next is examining in patenting. So examining involves refers to the process by which a patent office reviews a patent application to determine whether the invention meets the necessary legal and technical requirements to be granted to a patent. This process is typically carried out by the patent examiner who accesses the application to ensure that the invention is novel, non-obvious, and useful. The goal of the examination is to determine whether the claimed invention is patentable under the relevant laws and regulations. Grant of patent. The grant of a patent is the formal decision by a patent officer to issue a patent for an invention, recognizing it as a legal protective intellectual property. Once a patent is granted, the invention gains exclusive rights over the invention for a period, typically 20 years from filing date. Here we have come across patent and process of patenting. Thanks for watching.